He built their empire for 11 years. Then they sued him for leaving. A man spent 11 years building someone else's dream, and the moment he tried to protect his own, they took him to court. The plaintiff had worked as a senior operations manager for a mid-sized logistics company in the industrial outskirts of a Rust Belt city. For over a decade, he had been the kind of employee companies quietly depended on, the one who answered calls at midnight, who covered shifts nobody wanted, who turned a struggling regional depot into one of the company's most profitable locations. When he retired in the spring, his exit was cordial. There were handshakes, there was a cake, there was a framed certificate on the wall of his garage. What nobody told him was that the certificate was about to become the least significant document in his life. 4 months after his retirement, the plaintiff began construction on a small workshop at the rear of his property. A modest structure, concrete block, roughly 800 square feet. He'd dreamed about it for years. A place to restore vintage motorcycles, to finally have the quiet he'd earned. He pulled the appropriate permits, hired a licensed contractor, and broke ground in late summer. Then the letter arrived. His former employer, a company he had given over a decade of his life to, claimed that the rear corner of his property, specifically a 14-foot strip of land where 2 of his workshop's foundation walls now sat, legally belonged to them. The company had purchased the adjacent commercial lot 18 months prior, and their surveyor had flagged an encroachment. They demanded the structure be halted, partially demolished, and the land vacated. When the plaintiff refused, they sued, seeking $47,200 in damages, survey costs, legal fees, and the forced removal of the partially completed structure. The plaintiff was devastated, not just financially, but personally. This was the company he had defended in vendor meetings, the company he had sacrificed holidays for. He counterclaimed for $31,500, representing construction costs he stood to lose. Standing before the civil court judge, the company's attorney presented a clean chain of title and a certified survey clearly placing the disputed strip within their client's newly acquired parcel. Their position was precise and well documented. The encroachment, they argued, was not sentimental, it was mathematical. A line on a map does not bend for loyalty. The plaintiff's attorney countered that his client had purchased his property 12 years prior, based on a survey and deed description that placed the boundary 6 feet further into what was now the company's lot. He had paid taxes on that strip. He had maintained it. He had every reasonable expectation it was his. His surveyor offered a competing reading of the original plat map, one that suggested the company's own survey had used a misidentified iron pin as its starting point. 2 surveyors, 2 answers. The judge looked like a woman being asked to choose between 2 weather forecasts for a day that had already happened. Then, 3 days before closing arguments, the plaintiff's attorney received a document from a title insurance archive that nobody had thought to check. It was an old boundary agreement, signed 14 years ago, before the plaintiff even purchased his home, between the original owner of his property and the industrial concern that had previously occupied the adjacent lot. That agreement, recorded but never indexed under the current parcel number due to a clerical filing error, established a mutual acknowledgement of the boundary line. The line it described matched the plaintiff's survey almost exactly. More critically, the company that had signed that original agreement was a predecessor entity that the plaintiff's former employer had absorbed through acquisition, making them legally bound by its terms. The company's attorneys requested a continuance. The judge denied it. In her ruling, the judge found in favor of the plaintiff on the boundary question. The predecessor agreement was valid, binding, and dispositive. The encroachment did not exist. She awarded the plaintiff $13,500 in construction costs and an additional $8,400 in legal fees, $39,900 total. The company's claim was dismissed entirely. The plaintiff later finished his workshop. He was seen by at least one neighbor crying quietly in the parking lot of the courthouse before he drove home. The company filed no appeal. Whether that was acceptance or strategy, nobody said publicly. Here's what the case left behind, beyond the judgment. A man who gave 11 years to an organization discovered in the sharpest possible way that institutions do not carry loyalty in the same pocket where they carry legal standing. The document that saved him existed for 14 years, buried in an archive, misfiled under a number nobody thought to look up until the pressure became unbearable. Which raises the question worth sitting with. If that document had never been found, if the filing error had simply stood, would the outcome have been justice or just the law?